Welcome back to Good Law, Bad Law. My guest on today's episode is Peter Baer. He's a professor of law and philosophy at the University of Nevada, Las Vegas Law School. We're talking about the Constitution, impeachment, and morality. Is that enough of a tease for you? We explore what the moral underpinnings are, the natural rights underpinnings are of the Constitution. Peter has done a lot of thinking and writing about Immanuel Kant and his philosophy as it both informs and is influenced by the Constitution almost 250 years ago. What that has to do with values and moral principles of due process and liberty and dignity, and how all of that relates to the impeachment that we have just witnessed of President Donald Trump. We have a really juicy, thoughtful, and I think pretty fun conversation about all of those things. So please stay tuned and enjoy. Send your comments, your feedback. I'll look forward to hearing from you. And now enjoy this episode of Good Law, Bad Law. As we record this episode, we are one day following the impeachment of President Trump. It also happens to be my birthday. And I listened to a good many of the speeches on the House floor, and both sides, very interestingly, invoke the Constitution. And that's what we'll be talking about today. What is the Constitution and what is due process? Where did these ideas come from, these big ideas that we reference frequently, but don't really, I think, explore enough to fully appreciate just how profound and how great they really are. And to help us understand these issues better, is my guest today, Peter Baer, a professor of law at the University of Nevada, Las Vegas, UNLV Law School. Peter, thank you very much for being on Good Law, Bad Law today.
Well, thank you very much for inviting me.
I'm really excited about this. We are in some very heady times politically, of course, and legally, and the intersection of law and politics as we see it playing out in the impeachment of the president, only the third time in American history that's happened. And as you and I discussed when we were setting up the episode for today, we may reference impeachment, but we're not really so much talking about the details of impeachment, more the idea and the ideals of the Constitution and how perhaps we can understand those better as, again, they've been invoked so frequently, though superficially in the last months that we've been discussing and worrying about and debating impeachment. You wrote a book most recently with a very philosophical title, and we'll ask you about that. The book Deontological Originalism, Moral Truth, Liberty, and Constitutional Due Process. So maybe we could start there, and that way, you can kind of set the table for us in terms of your approach to and understanding of the Constitution and its role. So take us there. How does your book address this, and what does this say about your understanding of the meaning and the sort of underlying sources of the Constitution?
Well, first, I have to tell you, it's a book-length article. It was published by Thurgood Marshall Law Review. It's about a 460-page article, so I guess in that regard, you can qualify as a book. I think even in the electronic age, we're still making distinctions between articles, particularly in law, published by law reviews and books. But oddly, I'm really delighted it was published by a reputable law review because it has electronic platforms such as Lexis and Westlaw, where many books don't, and so there's a better chance that some researchers will find at least parts of my work. But deontological originalism is a culmination of over 30 years of thought about and study about the Constitution and its basic premise, which at once is both very controversial and at the same time well settled. And we'll talk about why that is in a moment. Its basic proposition is that the overarching purpose of the Constitution is to create a nation ruled by principles of liberty, and that government offices or officers, such as presidents or whatever, violate the Constitution, particularly the Due Process Clause, if they act immorally. The actual definition from our history and from theory of a violation of liberty is actually an immoral act perpetrated by an office or officer of government or some agent of government. That, I've become convinced in my years of study, is if you had to condense the meaning and purpose of the Constitution into one idea, it is that even though the old adage, nobody told you life was fair, the framers of the Constitution, and then as amended substantially after the Civil War by the Reconstruction Congress, the purpose of the Constitution is to guarantee that your government will be fair. It may not be smart, it may not be wise, it may not be efficient. Its politics may be bad, but it has to treat you with minimum fairness. And so I'm sure we'll get to at some point how to define fairness. But the title, Deontological Originalism, is, I hope, the most jargon I'll give you. Everything else, I'll try to keep away from jargon. But deontology,
well, that's a big one. It's a big word. Yes.
Yeah, but it's a useful word because it's not just a pompous sounding word. It really, you want a word that conveys this meaning. And deontological comes from deontology, which is that branch of moral philosophy that believes that moral principles, what is right, what is wrong, are not humanly created. They're not human ideas. They aren't derived from human imagining. Rather, like physics, like chemistry, like the planets, they precede humankind. They exist in some sort of natural form in nature, in the order of things, in the proper existence of things. And human beings have an affirmative obligation, to the best of their ability, to discern these pre-existing moral precepts and to live by them. So the deontological part is a belief that there are moral truths. It's not just a matter of opinion. There is right, there is wrong. And the framers of the Constitution certainly believe that. They were part of the generations that had read moral philosophy and political philosophy and legal philosophy, such as Blackstone in England, and much liberal Enlightenment political philosophy that influenced the framers began with the premise that moral principles are handed from God, and therefore they are for human beings to apply, but not for human beings to change or redefine. So that's the deontological part. The originalism is that branch of constitutional study that tries to determine what did the framers intend, generally, and then with specific constitutional provisions. And most originalists believe that we have an obligation to follow the intent of the framers. Now, there are all sorts of subgroups and sub-branches of originalism. Very few originalists actually say that every single thing that the framers thought, terms like commerce, let's say, or executive should be applied. But all originalists, for any number of reasons, want to demonstrate that their constitutional theory is the one that the framers envisioned. So what I'm arguing in deontological originalism is that while there certainly are a lot of very specific and important provisions in the Constitution about separation of powers and then each branch's power and other specific provisions like amending the Constitution and the Supremacy Clause, the overarching purpose was to create a government that enforced as the highest law of the land the moral principles that come from the natural order of things. Is this kind of where you wanted to go?
This is fantastic, and I have already 3 or 4 questions before we
let me just sort of close it with this, and then you can jump in with the questions.
Yeah.
How do we know this? Or at least how do I know this? How do we know? The vast bulk of scholarship seems to agree, with very good reason, that the framers of the Constitution saw the Constitution as the legal enforcement of the Declaration of Independence. Mm-hmm. In fact, I think it was Chief Justice Warren Burger who in a speech really encapsulated it well by saying the Declaration was the promise, the Constitution is the fulfillment. Mm. The Declaration of Independence, it was a legal argument to justify the American Revolution. It was the argument to the world as to why the colonists not only had the right, but probably actually the moral obligation to do what so many people and theorists thought was per se wrongful, which is to take armed rebellion against your government. And as you recall from your study of the Declaration of Independence, it begins with like a legal argument. It begins with its basic conclusion, which is we can't wait anymore. The revolution has to come. And it's our obligation to explain why. And then it gives the law before applying the law to the facts. And the law was that because all persons, of course, the Declaration was all men, but we'll make it because all persons are created equal, and that they were, you remember the famous words that we
endowed
all
by their creator.
Right, with unalienable rights, meaning rights that human beings cannot take away from other human beings. And among the rights are life, liberty, and the pursuit of happiness. The Declaration in its first paragraph consistently tells us these are rights that come from God and nature's God. These are natural rights derived from the law of nature. And then, continuing its legal argument, the founders who wrote the Declaration said, all right, well, why do we have governments? Why do people band together to form governments? And then the classic kind of Lockean argument, to preserve these rights, to form a legal enforcement mechanism that has the sole lawful recourse to violence to assure that no individual or group deprives other individual or groups of their fundamental rights. And then the Declaration says, and when government fails to do this, and fails so badly and so persistently that no matter how many times you ask, no matter how many entreaties you bring, no matter how many arguments you bring, government's just, it's not going to change. Then you've reached the point where to preserve your own dignity and integrity, you've got to break away. And then I hope I have it right, I think it's the third paragraph. So I was just talking about the first 2 paragraphs. But the third paragraph, I think it is the lengthy dissertation of specific offenses that King George and the British government had imposed against the colonists, and the argument that the British government was simply not going to change, and therefore the colonists had no choice. It wasn't even for its own convenience or comfort. It to remain in a dignified moral position, they had to get rid of this government, or at least try. And this, in an odd way, is somewhat similar. I'm not prejudging. I'm simply saying, as a matter of ideas, this is somewhat similar to the idea of impeaching, let's say, a president, which is there may be specific offenses the president has committed or is alleged to have committed, but the concept of impeachment is you have a president who has so corrupted the office and is going to continue to do it that you have no choice but to get rid of it, rid of him.
That's exactly the parallel I was thinking about as I'm listening to you. Is again, both sides are, at least in the rhetoric, and I listened to a good many of the speeches from yesterday. It'll be a week ago when this episode airs, but both are invoking a certain moral authority. You know, those favoring impeachment saying, no, it doesn't mean that I hate Donald Trump or I hate what he's done or I hate his policies. I, as one who took an oath to uphold the Constitution and what it stands for, I am compelled to do this. And those who are defending the president similarly, but on the opposite side of the issue, say, I can't stand by and see the standards for what impeachment is, what is impeachable conduct, so lowered, this their argument. I am therefore compelled, not only because perhaps in a partisan sense I support this president, but I must support future presidents from also being subjected to a lowered standard of impeachment. So they're both really making morality-based arguments. Right? And that's, I mean, that in itself is so revolutionary in terms of what the Constitution was in its day and what it remains to this day. The idea that in a time when we still had kings and queens, you know, we had monarchs who were the law and who truly were above the law. I mean, you could not sue the king. You could not challenge the king's authority. You could not impeach a king. This idea that all of that makes what happened in 1776 and then 1789 so truly revolutionary.
And I'm sorry, not to be pedantic. I think you meant 1787.
1787. Yes.
But look, I get, you know, these are hard days to keep track. Just a couple of quick things, and then let's move into this. First, you said, and I agree with you, those who support impeachment are saying it's not that I hate Donald Trump. They may. I mean, they may hate him. They may hate his policies. What they're saying is that's not my motive.
Right.
That would be an illegitimate reason. The impeachment is saying the House of Representatives, which is authorized to impeach, that is to investigate and to decide whether the president should be impeached, has, through its investigation, reached a degree of certainty that Donald Trump has committed impeachable offenses, has attained that degree of certainty that it will impeach him and then demand that the Senate try him. So I imagine that there are members of the House of Representatives who truly despise this president and his policies, but that's not the reason. At least that's their claim. And I believe them. Now, let's talk a little bit more about why this is a moral issue, as opposed to, because some would say, well, no, this is political, legal. Where's the morality in this? And here's the argument, and it comes from Deontological Originalism, the theory that I am trying to push. What is wrong with being a corrupt president. Why should that be unlawful? Why should that be a situation where, despite electoral popularity, the Congress decides he has to be thrown out, that he's so what's wrong with it? It's because he is so dangerous. Dangerous to what? The principles of our government. Well, which principles? Is it that technically he may define commerce differently than some members of Congress, or technically he may think that free speech is different than some judge thinks it is? No, it is that he has corrupted the principles of liberty. And the two allegations that apparently the House has drawn, and just as an aside, I don't know why they didn't take the time to do it. Maybe you have an idea. Emoluments violations.
Yeah.
I know there are lawsuits going on, but emoluments is not, it seems like something that is very graphic. If it can be proved, and again, I'm not prejudging, I'm just saying if it can be proved, you're saying, look at the president, look at how he is personally, financially bettering himself through his office. I don't know why they didn't go through with emoluments. And also, we may have time to talk about, I'm very distressed. In fact, I published recently an op-ed piece in the Las Vegas Review-Journal talking about this. I'm very distressed with Chair Schiff's refusal, the House's refusal to pursue its subpoenas in court, and to say it was roped up to play with the court. I think this is bad politically as well as constitutionally. I think it's going to give the Senate a route to acquit Trump. We can talk about that in a little bit.
Yeah. Well, but just real quickly before, on emoluments, for people who aren't familiar with this part of the Constitution, it's in the Constitution that the president essentially may not accept gifts, particularly from foreign powers. There was a great concern in the late 18th century that when there were still questions of whether you were loyal to the British throne or to this fledgling republic, there were concerns about corrupting influences and presidents accepting gifts or things of value. That was a real concern in those days, and I think this president from the beginning has violated the emoluments clause brazenly. But look, these are.
I think that certainly would have been worth Congress's time to investigate.
But they didn't like. I think looking at the polls, the political side of those managing the impeachment were concerned enough to switch from talking about quid pro quo to bribery. The thought that they would take on, a multi-syllable word like emoluments probably seemed like too much. But I certainly agree. It's there.
Oh, one other thing, Aaron. Again, just for those who are tuning into this podcast, I something you said earlier. I think you're basically correct about certainly at the time of the Revolution, England and other nations had very strong monarchies, but you have to remember that by the time of the American Revolution, there had been revolutions of sorts in England and various incarnations of Magna Carta, and from its first through numerous others. So the concept of an absolute monarchy that was above any question or above any review, England had gone far from that. And you're right, you couldn't impeach a king, but the monarchy had lost considerable power by the time of the Revolution. There was that precedent. You can argue that the American Revolution was a logical offshoot of these ideas.
Well, that's where they got the ideas, of course. But
sure.
But to go from George III to We the People, that was still a pretty dramatic
Yes, that
change in focus.
Yes, that is a huge. That is very important. So, all right. So where do we go now?
I mean, I have always been fascinated with the idea of natural rights and morality underlying the Constitution. I think probably a lot of people aren't even familiar with that, and what they know about the framers may be, to have been religious or to invoke God among the Jefferson, Hamilton, Madison crowd, meant something different than it does in 2019. So, say a bit more about that and the role of the concept of these being natural rights and how those informed these basic values in the Constitution: due process, liberty. I don't know if I know what pursuit of happiness means to me, but originally I think it was property that they were going to have inserted there, and somehow Jefferson changed that. But how is morality as a concept something that gives rise to the framework of the Constitution and its values?
Well, the natural law theory that predated the Declaration of Independence, that you get from Magna Carta, that you get from Locke, Rousseau, that you get from the legal theorists, that the colonists were influenced by the British legal theorists Blackstone and Locke. You're right. They all had this religious sense that God bestowed on humanity this special gift of uniqueness, of intellect, of advanced self-awareness, and the ability to discern right from wrong.
Mm-hmm.
And
mm-hmm.
I'm sorry?
Reason.
Right, reason, but for what? I mean, to what end? What is the point of reason? Is it just reason per se? So if you can reason out a great way to murder your rival, that's using reason. No. There is a purpose to it.
Yeah.
And the pursuit of happiness. When you look back at when that phrase was originally coined, and the predecessors to that phrase, and again, you find that references in Blackstone and such. It was always the pursuit of happiness within a moral framework. It was not simply doing, but the idea of pursuit of happiness is each individual may and perhaps even has an obligation to fulfill himself or herself to the fullest extent, whatever that may be. I mean, some people are artists, some people are business people, some people are science, whatever, but must do so with proper regard for the rights and dignity of others.
I mean, that sounds like what today we call libertarianism.
Libertarianism becomes sort of more specific, and I'm just not as up to date on libertarian vis-a-vis minimal government and such. The deontological originalism that I espouse makes the government the guardian of liberty, and therefore the guardian of morality. It makes the judges moral theorists, which is frankly what they are, although they will vehemently deny it. Certainly the dissenters, for example, in the famous Obergefell case, where the Supreme Court ruled that states must recognize same-sex marriages and treat it essentially equally with opposite-sex marriages. The dissenters all said this is a moral issue. It's not a constitutional issue. Judges are not moral arbiters, they are judges. But again, let's look at what liberty means. And from its, from early Supreme Court opinions through the 20th century and now, into the 21st century, even conservative justices like Felix Frankfurter, who were renowned for judicial restraint, that is, that judges should not act as super legislators, rewriting legislation or creating laws. Judges have to confine themselves to the fact and the record because of the power they have. Even Frankfurter over and over defined due process of law as basic decency, as fundamental fairness. And you probably remember from your common law classes, you'd read the cases about due process of law, and it would say it's about fundamental fairness. Well, what is fairness? This is something that President Trump is quite happy to invoke all the time.
He turns it upside down. That's
But how do we know? And that's something we'll have to mention. But what's he talking about when he says he wants fairness? Meaning what?
Fairness
he wants
to him.
To be well, yeah. But what he is claiming is that he is not being treated in a moral sense, in a fair way, in a way that comports with morality. When he says it's not fair, I mean, he's not saying, well, I'm being economically disadvantaged necessarily, or I'm being politically. He's saying, no, I am not being accorded the decent treatment that I should get or that any human being should get. Although you may be right, he may think that he's entitled to better treatment.
Well, it reminds me, Peter. There's a dispute that often comes up in trial, and I am a trial lawyer, so I've dealt with this issue a lot on the idea of prejudice when it comes to certain evidence. I've had this argument many times, and fortunately, most of the time, win this argument in front of a judge, where the question is a piece of evidence, whether it's a document or a record or a piece of testimony. The defendant will argue this is prejudicial and it should be kept out. The jury at trial shouldn't hear this. And my response is, okay, well, prejudice, all evidence that is adverse to you, that goes against you in some way, is in some way prejudicial to you, but it's not unfairly prejudicial. If we were to keep out any evidence that is prejudicial, where we define that as meaning it goes against your case, we would keep out all evidence from the other side.
So why
that's kind of how I think of Trump when he talks about fairness. He's not really talking in a grand sense about fairness or about due process. He's most of the time talking about unfairness in the sense of they don't like me, or that article, when said something critical of me. I liked the Washington Post when they wrote something favorable about me, but when they wrote something negative about me, that was unfair.
No, that is exactly it. As a trial lawyer, when we use the shorthand, it's prejudicial. That shorthand means what? That its propensity to mislead, its propensity to give a wrong or prejudiced impression is so great, and its probativeness, its probability of actually revealing facts or meaning is so small that it's unfair. That a reasonable jury, based on a lay sensibility, is not going to be able to understand what this is all about. It is going to be influenced by the prejudice. And as a trial lawyer, again, using the shorthand or the motto, what is the basic constitutional motto of a trial? What does the Constitution guarantee? Does the court say it all the time? It doesn't guarantee a perfect trial. It guarantees a fair trial.
Right, a fair and impartial jury. That's right.
All right, so I think we may be at the point. I mean, you're in charge of this discussion, but I'm wondering if we're at the point where finally we say, well, how do you know what's fair and what's not fair? Donald, I agree with you. Donald Trump's concept of fairness is entirely id and ego. It is there's almost no super ego. There's almost no sense of community. It's almost exclusively the Trumpian definition, it seems to me, of fairness is what he likes, and the definition of unfairness is what he doesn't like.
That's right.
So if something happens, he doesn't like it, it's unfair. This is an 8-year-old's definition.
Or a narcissist.
Oh, yes.
Although most 8-year-olds are narcissists.
We want to, we try to educate our children to realize that what's fair or unfair, right or wrong, goes beyond their personal comfort level. And that sometimes things happen that are uncomfortable, or they must do things that are uncomfortable because it's the right thing to do. So this, for a moment, this takes me back to deontology. There are two strains of moral philosophy, and then there are a lot of subsets. But for what's called meta theory, the highest theory, there are two strains. One is deontology, which, as I mentioned, is the idea that morality precedes human beings and human beings figure out what it is. The other is perhaps the more recognized terms, utilitarianism or consequentialism. And that's saying, well, the morally correct outcome is the one that benefits the most number of people or makes the most number of people happy. And then there are all sorts of subsets of utilitarianism because you immediately come up with problems, which is, well, if most people are happy to be racially prejudiced, if most people are happy to be murderers, if most people are happy to be slave owners, then under utilitarianism, doesn't that mean that slavery is moral? Doesn't that mean that murder is moral? That can't be right. We just intuitively know that's wrong. But as I argue in my article, no matter how you try to tweak it, the bottom line for utilitarian principles is you're basing morality on what somebody or some group wants. And the moment you do that, it's no different than what Donald Trump does. Mm-hmm. It's ultimately saying, if I can't have what I want, it's unfair. So I've got to, I know they've been debating this for thousands of years, but it seems to me remarkably simple. Morality must be deontological. It must be not what you want, but what you must do. To be moral, you have to, as the great moral philosopher Immanuel Kant, among others, argued, you've got to divorce yourself from your preferences. You have to somehow stand outside yourself and say, it doesn't matter what I want or what somebody else wants. I have to find a formula that will let me know what is right, regardless of what anybody wants. Which means, and this is very hard to handle. As a matter of fact, finally understanding this was like one of the big days of my life. My marriage, biggest day. Second biggest day, maybe my bar mitzvah. Third biggest day, figuring out why consequentialism is wrong.
Oh my goodness!
Because what deontology says is consequences do not matter in a moral sense. Yeah. If the outcome, right or wrong, does not matter on the consequences, which is why Kant famously wrote, "Let right be done, though the heavens tumble." And most people are very uncomfortable with this idea, but it means, for example, if torture is immoral, as a famous, perhaps overused example goes, if torture is immoral, you cannot torture a suspect to find out where the H-bomb that's set to go off in an hour is, even if torture will reveal that and save millions of lives. I think most people believe torture is immoral. Probably that can be proved, but I'm not even going to concede that for this argument. I'm just giving the most basic. So, how do we figure out what is or is not moral? And this is where deontological originalism goes into areas that the framers didn't. because as I've talked about deontological originalism with friends and colleagues who know about the Constitution, they'll say, but the framers believed that if the situation were dire enough, then due process gets put away, at least for the time being. Jefferson wrote that in correspondence. Their concept of morality was that natural rights are, in essence, a subset or part of natural law, and that there's also a concept of necessity, of survival, of logic in natural law that can sometimes supersede natural rights. That natural rights, should generally be enforced, but that there are times when it isn't. So if morality stems from natural rights, that must mean that there are times when you act immorally.
I'm thinking, listening to you, I mean, the Supreme Court, some of the darkest moments in the Supreme Court's history, as we look back, are those moments where it seems they have taken an amoral or a non-moral approach to
immoral. Immoral. I mean, people seem to avoid that phrase.
Yeah.
It's not
immoral.
Absence of morality. They take positions that are wrongful. But anyway, you were saying.
Well, I mean, I was just going to cite Plessy versus Ferguson. The termination. Dred Scott. Yeah, the Dred Scott case. Plessy reversed that.
And the Japanese internment.
The Japanese internment during World War II. I mean, these are moments where, quote, the greater good was used to justify, absolutely immoral conduct as we judge it today. But I want to go on that line of thinking. I want to go back to the Obergefell case because you mentioned the dissent, and I think, as we often do, we have a description that we always use for our episodes, and we provide links to things that we've talked about. I mean, clearly, we'll provide a link to your articles so that if people want to dive into 400 odd pages of this, they can and they should. But
and
also
very odd pages, yes.
But you didn't mention the majority opinion by Justice Kennedy, and it's a beautiful opinion. Everyone should be well worth reading it. And it seems to me that the idea that Justice Kennedy relies on really demonstrates what you're arguing for here, because he talks about basic dignity and not about what one thinks about same-sex marriage, but about basic human dignity. And it's ironic to me, given that, because Kennedy in that case joined the so-called liberals on the court, and it was the so-called conservatives on the court who were the dissenters, and it is the conservatives on the court who are most often associated with what we sometimes hear described as originalism. So, I mean, how do we square all of that?
Yeah. Their concept of originalism, of course, is much different. And ironically, of the four dissenters, one is Justice Clarence Thomas, who is the most vocal justice to argue that the concepts of dignity that can be found in the Constitution derive from the Declaration of Independence. And while, in recent years, the courts have tried to shy away from the Declaration of Independence as guidance, Thomas has been very adamant, linking the Constitution to the Declaration, but his outcomes, I disagree with. All right. And by the way, I think that Obergefell has its flaws, and there's some fascinating scholarship that's well worth reading about how even within that opinion, there's a little bit of sort of heterosexual supremacy kind of percolating in there, a little bit of supposition, a little smarmy supposition here or there. But overall, I agree with you. It is a beautiful decision written by a justice who believed in the poetry of law.
Yeah.
And I think it is the greatest single decision ever from the Supreme Court simply because, I mean, yes, we have Marbury versus Madison, but this is the one that you look at and you say, the framers never saw this one coming. You could argue almost any other opinion if you sat down with them and said, well, we're going to get rid of slavery. It's going to cost a lot. We're going to get rid of slavery. And then African Americans are going to be treated equally with white persons and this and that. I think the framers could say, all right, we're not used to that, but we can see it. Mm-hmm. This is the one I think they'd say, I have no idea how you got from here to there.
Right.
All right, but here's the thing. You're right. The concept that Kennedy for the majority uses is based on principles, not well defined, but principles of dignity that you can find in many earlier important opinions. Those same ideas are in Brown versus Board of Education, for example, the desegregation opinion, although not quite written in the same language. But what the court has told us about due process of law is, what due process of law says is that the government at any level from any office must treat people with the dignity that is inherently theirs. And while the court doesn't exactly say this, I argue in my article that the court is embracing the dignity principles of Immanuel Kant, not the dignity principles of John Stuart Mill, or others who perhaps a little more consequent, yet utilitarians.
Yeah.
So I think this is the moment where we can finally ask, what's really going on in opinions like Obergefell? What can we find to link it all? What is it about not allowing otherwise eligible unmarried same-sex adults from marrying? What does that have in common with forcing children into racially segregated education? What does that have in common with refusing to allow women to be partners in the litigation section of a law firm? What do all these issues of fairness?
How about any First Amendment? How about any First Amendment case?
Any First Amendment, any Fourth Amendment, any Sixth Amendment, any Eighth Amendment, anything. You're right. But this is why it took these 460 pages. Anything in the Constitution, even separation of powers.
Yeah.
The brilliant Justice Felix Frankfurter, I use him a lot. Frankfurter and the second Justice Harlan, they understood due process. Their problem, as I see it, was they were timid. They articulated the ideas of due process brilliantly, but they were afraid to apply it because they thought it would be too much power for the court. But what are these concepts of decency and fundamental fairness? I think they are, in essence, Immanuel Kant. And let me try to explain Kant's theory of dignity very fast. He had three what he called categorical imperatives, meaning these are things that people must do. The first one, categorical imperative one, is fairly well known, and it is, you cannot act by any maxim, meaning any principle, any idea, that you would not want to be a universal maxim. This is, in essence, the golden rule.
Right, exactly.
All right, so in essence, it's saying, if you have a principle of morality, it can't just be yours, for you. It has to be universally applicable to everyone similarly situated. So otherwise, it's not quite do unto others as you would have others do unto you, because, of course, Kant as a deontologist believes it's not how you would have others do unto you. It's that this is how natural existence would have it done. But the point is still the same. His first categorical imperative is a moral maxim applies universally. You can't say, well, we're a different culture. Your culture might believe that women are equal to men, but now I'm from a culture that believes that women are not equal to men. Who are you to judge my culture? No, moral principle has got to be universal. That's fine, but that's not enough. Because that would justify immoral conduct so long as it's universally applied. So, for instance, let's say I believed that if you insult me, I can kill you. And I said, of course, if I were to insult someone else, they could kill me.
Yeah.
That would meet Categorical Imperative 1, because I'm not saying I get to insult people, but they don't, and kill and not be killed. But if somebody insults me, I get to kill them. You say, no, the universal maximum. Whoever is insulted gets to kill the insulter. So Kant understood we need something else. We have to know when the universal principle is moral. And he wrote, when dealing with others, you cannot treat them merely as means to what you want. Rather, you have to treat them as ends in themselves, that is, as persons with dignity, because they can understand moral precepts. That's what makes them dignified. And therefore, you cannot treat them merely as objects. You have to respect them. How are we doing?
No, I'm just I'm awed. I mean, that is
so. Well, no. So, yeah. It's a difficult. And Kant wrote shortly after the American Revolution. He wrote these principles, and I believe that if he had written them before the Revolution, they might have been more influential than Locke on the framers. But while Kant's theory never allowed for a revolution, which is kind of neo-Kantians, those who modify Kant, think that there are ways to allow for the American Revolution. He was profoundly affected, and Kant wrote about due process in ways that we have adopted. But that this concept, you cannot treat people merely as objects, merely as means to your ends. You have to treat them in ways that respect their dignity. First, of course, he understood we all treat people as means. You're using me for your podcast. I'm enjoying the podcast. I'm using you.
Hope so.
What Kant was saying is you cannot treat people in ways that if you were rational, you could never approve. So that's, again, you've got to step out of yourself. You can't go by your preferences, your wants, your desires, your predilections. You have to step out of yourself and say, if I were a rational person, would being treated a certain way be acceptable? And while there are vagaries, the basic notion of not treating people merely as means is you can't objectify them. You can't simply turn them into objects like machinery and tools that you can use, you can abuse, and you can throw away. So, you give me any due process problem. If it's a violation, it's because the government has failed to treat people with basic dignity. If it survives, it's because they've treated people with basic dignity. So take a criminal. Criminal does not want to be investigated. Criminal does not want to be caught. Criminal does not want to be tried and convicted. That's understandable. But if the criminal can step outside of herself and say, as a rational person, I can understand why. If the police have probable cause, they can obtain a warrant and search my house, even though it's my house. Of course, I don't want my house searched.
Mm-hmm.
But I can understand why proof of probable cause shows that the police are not simply going on a fishing expedition or out to get me or desperate, but rather they have amassed sufficient evidence to justify invading my privacy for a certain limited purpose. And as a rational person, I would have to agree that if they search my house with a properly issued warrant based on probable cause, that I haven't been harmed. I don't like it. It hurts me. I'm aggravated, but I have not been harmed in a moral sense. Any due process. Is any criminal defendant entitled to competent legal assistance? Because the criminal process, even at its simplest, is so complicated that a layperson will get lost in it. So if the law allows laypersons to be convicted without access to counsel, it's just treating them as an object to convict them. Am I making sense?
Total, absolutely so. But what I'm wondering as I'm listening is a two-step process, because ultimately we're going to circle back to impeachment and how that.
And we have to get back to Obergefell for a second to see how it works there.
Well, and so to take the categorical imperatives of Kant and you've given us some illustrations of this, but we have to apply those to some concept of government and the role of government and the limitations of the role of government versus the citizens that elect the government and that empower the government. So, due process is something we may not think of as due process in our interpersonal relationships. It's something we think about in terms of the relationship between the government and a citizen. So
exactly.
Right. So yeah, go ahead.
Right. So, according to basic Kantian moral theory, individuals have a moral duty to treat each other as ends in themselves and not merely as means. Government exists to help people, as the Declaration says, pursue happiness. Mm-hmm. So that you can walk around with money in your pocket with some reasonable degree of certainty that it isn't going to be stolen from you, and with the certainty that if it is stolen from you, that's against the law, and that the police are authorized to hunt down and arrest, and then the state can prosecute and convict your assailant. The due process clauses, Fifth Amendment for federal level, 14th Amendment for state level, guarantee that government will not, as government enacts laws and policies, as government enforces law and policy, that government will do so without violating liberty principles. That is, without, and this is where deontological originalism takes me, without violating morality, without treating persons as merely means and not ends. And I say persons because deliberately the due process clauses talk about persons. It's not citizens.
Yeah. Right.
No. So any person, as far as I'm concerned, and I know there are some Supreme Court cases that limit this, but as far as I'm concerned, any person who comes under the jurisdiction of the United States in any manner is protected by due process of law. No American governmental officer can treat any person, therefore immorally.
Well, we've allowed international terrorists due process if tried in an American court. So
if tried. But we also know that there are still purported terrorists sitting in Guantanamo with files that probably say nothing.
That's true.
And they should be
for the due process reason.
Where's the due process in that? How could a rational person who says, well, they could be dangerous, and therefore I don't want them released. No, that's not the rationality Kant is talking about.
Yeah.
No, that is the selfishness, the consequentialism, the me-ism that deontology says cannot exist. What you would have to say is, I can't keep a person incarcerated for so long without proof that that person has actually done something to deserve the incarceration, and without allowing that person reasonable opportunities to demonstrate that, in fact, he shouldn't be incarcerated.
Mm-hmm. To defend
and that all goes to fairness, because doesn't that all go to, are you treating the person with dignity? Are you treating the person as a person, or are you treating them as merely an object to be used? So when the government says, well, we can't release these Gitmo prisoners because it'll be bad politically, or it'll look bad, or even they may not have been radicals when we arrested them, but they hate us now, and if we set them free, they'll fight against us. If we created that radicalism, we can't then justify keeping them imprisoned because we turned them into radicals.
Yeah.
That's why...
Because you have to apply the principle almost
neutrally,
regardless of the consequence. You have to apply the principle because the principle is the principle. It's correct. It's right.
That's why if the heavens tumble, it's too bad.
That's why we let people we know almost to a certainty to have committed a crime to go free if there is a violation of some due process principle, because the principle is more important than the particular outcome in any single case.
Right. Now, of course, you have to remember, it's not that morality is relational. It's not, if something is immoral, it is immoral. And you cannot fight immorality with immorality. You must use moral means. But, of course, not every immoral act is as serious as every other. You're a trial lawyer, so you know the idea of harmless error. If a judge makes an incorrect evidentiary ruling, technically that incorrectness treats the party who was denied the evidence as an object. But that one instance may not be sufficient enough to render the entire trial void. That
comes back to the issue of prejudice. An error is not enough. It has to be a prejudicial error. It has to be
exactly,
without which there's no real unfairness to the error.
Well, no, or the error could be unfair, but it isn't unfair enough for what the person says should be the proper recompense, the proper outcome. So you could have a trial with several procedural errors, but they really did not impinge on the defendant's or the prosecution's ability to present the case. But you could have one error that is so huge that you say, this is too much, like keeping African Americans off a jury.
Yeah.
Or you could have a series of smaller errors that a court of appeals says cumulatively have rendered the trial too suspect. So, and we can link this now, if you want, to impeachment, which is the notion that you could have a single act by a president that is so terrible that a rational Congress could say to keep that president on as president is a threat, a continued threat. I guess the popular phrase is now existential threat to liberty. Or you could have what is sort of going on here, which is there are, I guess the House would say each article is sufficient. But the Senate could also say, I'm not sure that each article, if proven alone, would be sufficient, but if you put them all together, it's a president who is so hostile to the concept of liberty that we can't keep him. Do you see what I mean?
Yeah.
Yeah.
And they've talked about that. It's not just, they're focusing in on Ukraine and what happened, but there's clearly other incidents that are informing the significance of the Ukraine episode.
Absolutely.
Even though they didn't result in a separate article of impeachment, they're clearly informing.
It'll be part of the overall proof and absolutely integral. And again, I'm not prejudging this saying here's how it would be argued one way or another. Absolutely integral are Trump's tweets and on-air statements where he he in essence says, I did nothing wrong, I will do it again. China should be investigating my opponents. Russia, hack computers and give us information. That's all vital because, at least from the prosecution's point of view, it's saying you might look at the one incident in the Ukraine and say, gee, that's terrible, but I don't think it's enough to throw out a president. But if you say that incident is not only bad in and of itself, but it's indicative of what this president is going to do and has done.
Mm-hmm.
You can't have a president who is simply going to use his office as a device to try and weaken his political opponents. You see what I mean?
Yeah, absolutely.
So, I know we're jumping around a bit, but I didn't want to leave Obergefell.
All right. Well, let's round off on Obergefell because it is.
We're running out of time.
I mean, we're good, but let's come back to it and we'll finish there.
All right. So, what? And again, Darren, you're absolutely right that insofar as the due process clauses are concerned, that only covers governmental action. In fact, there is only one part of the Constitution that directly regulates private persons, and that's, at least is the only one I'm aware of, and that's the 13th Amendment, which prohibits slavery. And that is self-enforcing, although there are statutes that enforce it. But the 13th Amendment prohibits not simply government ownership of slaves, but any private person from owning slaves or compelling involuntary servitude. But you're right, everything else is about government behavior. But then the agents of government can use their lawful authority to pass statutes and policies which enforce moral principles. So in great measure, let's take the civil rights laws as a very obvious example. It's true, a private employer who refuses to hire African Americans, there's no 14th or 5th Amendment claim, no due process claim against that private employer because those clauses only apply to government actors. But Congress has its authority under the Constitution to regulate commerce and to enforce the due process clauses, and it can do so against private parties. So that's how government can reach into private conduct to help enforce Kantian-type principles. What's wrong with refusing to hire African Americans? Well, because you're using race as a proxy for competency, or you are using your distaste for race as a device to disadvantage someone who's done nothing wrong to you. Either way, you're treating that person merely as a means for your own gratification. You're not treating that person as an end. To respect that person, you would judge that person's competency. So, Obergefell, there's certainly a long and unmistakable tradition that government-sanctioned marriages are opposite-sex marriages. But the Obergefell court asked, and you also remember there was U.S. versus Windsor a couple of years earlier, which asked the same question at the federal level under the Fifth Amendment. And that opinion also authored by Kennedy. The government asked, the justices said, on what basis is the government either refusing to recognize same-sex marriages or is recognizing them but treating them differently than opposite-sex marriages, maybe limiting adoption rights or who knows what. And in a long coming but stunning reversal of the scientific presumptions and sociological and moral presumptions of the past, the court finally said it's based on outmoded beliefs and prejudices that same-sex couples, probably homosexual couples, are engaged in some sort of immoral practice or immoral ideas and are therefore unworthy of the legal status of marriage if they want to get married. But in point of fact, an otherwise eligible same-sex couple poses no risk to society that isn't posed by a heterosexual couple. Or not, I'm sorry, I should say opposite-sex couple. And therefore, to restrict marriage rights is simply a device to advance outmoded prejudices and to inflict societal harm on these individuals and their children. You remember the court accented the effects on the children.
Mm-hmm.
And that is, as the court said, and it's based on many earlier cases, the bare desire to cause harm, the bare infliction of prejudice is just it's an illegitimate basis for government conduct. Why? Because it's wrongful, it's immoral. So once again, we see that the promise of due process of law, the greatest promise in the Constitution, is based on a question of is government treating people morally or immorally. Now, if the government says we're not going to let married women contract independently from their husbands, which of course we don't do that anymore,
but we did. We did that for a while.
Yeah, we did. That's a violation of, well, some will say equal protection, but as the Supreme Court has told us, equal protection is a species of due process.
Mm-hmm.
The same way free speech is a species of due process. The same way as right to be free from unreasonable searches is a species of due process. So there is no legitimate basis to demean women by saying if you get married, you will be subservient to your husband and you can't contract without your husband's permission. Now, when the law says we are not necessarily we're going to make the contracts of minors voidable. Why? Well, we don't think minors have the maturity and understanding to realize fully the way an adult would what a contract is about. Is that saying that minors in certain ways are not as advanced and such as adults? Yeah, but we can demonstrate this as a fact.
Mm-hmm.
And therefore, we are not demeaning the dignity of the minor. We are simply enforcing a rational principle. The same thing as the Americans with Disabilities Act, of course, have provisions that say if the unfortunate reality is a disability actually does prevent a person from performing certain work, and there are no reasonable accommodations to be made, then the employer can discriminate on the basis of the disability. The argument being, of course, it's unfortunate, it may be nobody's fault, but if a disability renders a person unable, let's say, to do strenuous physical labor, then it is not demeaning the dignity of that person for a foreman to say, I'm sorry, I can't hire you for this job because you just cannot do it.
Yeah.
It's not my prejudice. It's not my desire to put you in a socially weak position. It's an unfortunate actuality.
Well, that's why I've always found it fascinating. Again, we talked about the specific case of the same-sex marriage decision, Obergefell, but this idea that the Constitution, I mean, here, having this conversation with you is fascinating to me because on the one hand, we see many ways in which the Constitution has been a flexible document. It's been a flexible document because African Americans were not included in the idea of citizenship in the original implementing of the Constitution. Neither were women, and Justice Kennedy referring to outmoded ideas about what marriage is, and emphasizing the dignity of an individual human being to make that choice without interference from the government. Yeah. I mean, that shows the Constitution as as a very flexible document for something that was written, almost 250 years ago, and yet it is, as you argue, based on categorical imperatives, not flexible ideas of what is moral in terms of 2019 versus what was moral in terms of 1819. These are bedrock imperatives based on pre-human values of what is moral and right, dignity, fairness,
which is why, and it's not just being argumentative because lawyers are argumentative. The Constitution is not a flexible document. It is an inflexible document.
Yeah.
At least that's how I view it. In fact, before I wrote Deontological Originalism, I introduced many of the, I have no absolute original ideas. I'm taking other people's ideas and trying to put them together in a way. But I introduced my concepts in an article called, now I'm trying to back, but it's Sacrifice and Sacred Honor, Why the Constitution is a Suicide Pact. And there's this old adage, the Constitution is not a suicide pact, meaning you can't enforce constitutional rights in a way that's really going to damage the nation. And my first, use of Kant and such, in theory, I wrote, no, the Constitution is a suicide pact in the sense that you have to follow the moral precepts of due process wherever they will take you. So it's not a flexible document. It is inflexible. It is, at least as I read it and understand it. And there are many who will disagree. Many who will say I have it absolutely wrong.
I guess I meant flexible, not in the sense that the words and values are malleable to fit the occasion, which has been an often used argument against so-called liberal decisions like Roe versus Wade and Obergefell and others. I meant flexible in the sense that the bedrock moral underpinnings of the Constitution are the framework that then is durable enough because the values are themselves so true and correct that it can be applied over the course of time.
Be applied.
And must be, yeah, exactly.
Yeah, see, so we're the flexible ones. Yeah. The document, the idea is inflexible. We are flexible enough to, at last, discover and have the fortitude to reject our errors and to do better.
Mm-hmm.
It's not that the document is flexible because now we recognize the equal dignity of men and women, the equal dignity of races, the equal dignity of LGBTQ individuals and such. No, we're the ones who had to be flexible enough to learn. Document was always there saying this, the moral standard is absolute. You've got to meet it. But again, this is how I see it. There are many who will say, no, this is not what the framers were really doing.
Well, so let's finish, Peter, where we started then on impeachment. And there's been a lot of, I'm not trying to turn you into per se an impeachment expert here, but the Constitution again is sort of, I think, deliberately vague about the grounds for impeachment. We've heard a lot of debate about that. What is a high crime or misdemeanor, after all? But from your standpoint, as one who sees the natural law-based moral underpinnings that are the values, behind the Declaration of Independence, behind the Constitution, we heard a lot of people invoking the Constitution, but how does the Constitution apply here? Obviously Trump has been impeached now. Is that correct? And if so, why is that correct, given what we've been talking about for the last hour?
Well, yeah, I understand that there's a lot of ambiguity, and I'm certainly not the expert that, say, a Lawrence tribe is. The professor from Harvard Law
From
School
Harvard, yeah.
who just recently co-authored a fascinating book on impeachment. But again, the basic premise is deceptively simple. And I have researched and written a bit on this. The basic premise of impeachment is that comes from the framers' belief that the term high crimes and misdemeanors is their shorthand for saying that Congress, which inherently is a political body, and we expect members of Congress generally to act politically. They will vote for legislation, they'll support legislation that they politically like and oppose legislation they politically don't like. But for impeachment, the members of the House and then the Senate are supposed to step outside of their political biases and preferences and ask the fundamental question: through this president's conduct, has the president demonstrated that he or she is a threat to the principles of the Constitution, is a threat to the liberty principles, so that regardless of popularity, as a matter of detached, neutral, moral reason, we can't let him be president anymore.
Mm-hmm.
Now, this can be because of one terrible crime he committed. This could be by a series of acts that may arguably not be criminal, but are so abhorrent to fairness and liberty. They were saying this president can no longer represent us. But the important thing is, it can't be political, although, of course, we're seeing the politics. The House cannot impeach by saying, I don't like these policies, or I'm sorry that this guy was elected. The House has to say, we didn't realize when he was elected that he was going to do things that were going to imperil the integrity of the nation.
Yeah.
And no rational voter, no matter how much they like or dislike policies, would want a president to remain in office if that president is a true threat to the integrity of the nation, the principles of liberty. So the House is saying that we have evidence to show that that is exactly Donald Trump's status. Love him or hate him, like his policies or not, what he is doing is actually a threat to the nation that is so profound and deep that he has to go.
Well, that's why I think the people who really most clearly demonstrate what you're talking about are those moderate Democrats who Nancy Pelosi probably worried about in the days after the Mueller report, and why initially she wasn't pushing for impeachment until the whole Ukraine scandal broke.
Right.
Those moderate Democrats who stepped up to vote for impeachment, even though it has been widely, said that they do so at great risk of losing their seats because they are coming from districts that turned Democrat, but that voted in the 2016 election for Trump. So they made the votes they did even against their own self-interest, politically speaking.
Right. Which was their duty.
Which was their duty, exactly. Which was their moral duty.
Yeah. Right. And I don't want to, disparage in any way members of the House who may come from very safe districts who have had long-standing concerns about this president. Yeah. I'm not prepared to say that their votes to impeach were based on improper motives.
Right. No, I understand.
Now, there do appear to be a slew of improper motives already in the Senate. It is one thing for Mitch McConnell and other Republican leaders of the Senate to say, we're going to work with the executive branch on the impeachment trial the way judges will often work with parties in litigation to promote efficiency and completeness, to schedule things. And
that's not what they're doing.
Right. And, those are neutral principles but the sense we are getting, and I'm saying sense, I'm not sure it's been proven yet, is that McConnell and others are trying to really pave the way to assure an acquittal. That, I have to believe the framers would say, is an abuse of their power.
I mean, I think so, and we can end here too. I mean, if the Senate is the jury, which it is, they are the deciders. I mean, the Senate is analogous to the jury in a criminal case, and the president is the defendant. How can the jury coordinate with the defendant on the defendant's defense?
Not morally, no, they can't.
Well, right, exactly.
Look, I expect Republicans are going to not want to get rid of President Trump. I can expect that Democrats would love to find a legitimate way to get rid of President Trump. This is the one time in the Constitution where the framers expected the members of the Congress to put aside politics. Now, I know there are theorists who say the framers always understood this would be a political endeavor. But still, I think the better interpretation is that the framers expected more from the House and the Senate than simply voting their political preferences.
But again, and I mean, not to reopen all of what we've been talking about, but the entire Constitution actually requires that, right? I mean, if you're a legislator and you say, I don't like a particular type of speech, so I'm going to legislate against speech when it comes from Mormons, or when it comes from Jews, or when it comes from socialists, we would say that the First Amendment says you can't do that.
Yeah, and we would say that it is so well established that these legislators do not have a principled basis to say, I'm legislating a certain policy and I'm trusting the courts. If my policy happens to be unconstitutional, that's the court's business.
Absolutely. But I'm just saying, it's not the impeachment isn't the only time when a legislator should be expected, if they've taken an oath to respect the Constitution, where they are expected as legislators, though they may have a policy agenda. I don't think this is unique in our expecting a legislator to put aside their personal views on things, and if those conflict with the values of the Constitution. And that's why, I mean, we call it partisan when they're voting along a political party line, but it's still personal. It's their personal political views rather than their institutional moral sense of what's right and wrong.
No, I think that's a very important point. You're right. Their pledges as legislators to uphold the Constitution. Now, I think you make a very, very important point. I am willing to cut legislators a lot of slack because they're legislators. Mm-hmm. Their job is to legislate. Their job is not to be constitutional experts, except I think in the general enough sense to know better than to do some of the things you were just talking about. The same way as we expect the police to understand constitutional limits, but we don't expect them. The court said they can't be constitutional scholars. They may engage in searches that they have a sense skirt the edge, but they genuinely think they're not crossing into unconstitutionality, and they'll rely on the courts to let them know if they were right or wrong. Do you see what I mean? Mm-hmm. I'll cut legislators a lot of slack in that if there is any plausible constitutional argument to support their legislation, I'll say they acted in good faith. So if you're saying they pass a law that says women can't speak or Muslims cannot protest, well, I don't see how any legislator in good faith could think that's lawful. But this actually gives us an interesting way to end on what's going on with President Trump, because, and this worries me a great deal, one of the articles of impeachment, obstruction of Congress, obstruction of justice, is claiming that the president's invocations of executive privilege are unlawful obstructions of justice. That's because Adam Schiff said he would not, quote, play rope-a-dope with the courts and try and enforce the subpoenas. I think that's really unfortunate. I'm 99% certain that Trump's extraordinary reading of this Article 2 of the Constitution, the president can do anything, is wrong, and that his invocations of executive privilege are hugely excessive. But we traditionally look to the courts to make that determination. Now, I may be wrong about this, but it seems to me that if the House had enforced the subpoenas, even if it would take months, and I think they could get expedited reviews, but even if it took months, and the court said to Trump, you've got to produce those witnesses, you've got to produce those documents, and then Trump refused, then I don't see how the Senate could ignore that. But now the House is saying, we, the House, think that the president's interpretation of his Article 2 powers is excessive. I'm afraid the Senate will say, well, but we're the triers here. We're the judge and jury, and we don't agree. And as the courts have not told us we're wrong, we're going to say that the president was attempting to protect presidential integrity and not obstructing justice. If the courts... I'm worried about it.
Yeah, I mean, I see your concern about how the Senate is going to, how the Republicans in the Senate are going to use what's happened as a way to form an argument in defense against impeachment or conviction against conviction.
Right.
However, I mean, I do think that this is really categorically different from anything we've seen, in that Nixon withheld the tapes on grounds of executive privilege. That went to the Supreme Court, and that is what ultimately undid Nixon and forced his resignation. But until that time, he produced witnesses. The White House produced documents, many of them. So did the Clinton White House during that impeachment. What Trump has done here, in fact, I don't know that I've ever heard Trump invoke executive privilege. What he's invoked is that the impeachment inquiry was a hoax, is a scam, is a sham. The entire thing is ridiculous, as is a witch hunt, and I'm not going to cooperate with it in any way, in any respect, to any degree. I mean,
he's finally he's listened enough to his advisors to start saying, that he's protecting the presidency, that the House can't get this because they don't have a basis, because they haven't given him due process.
But the House can. I mean, that's on its face false. The House is the sole constitutional, has sole constitutional authority in impeachment. If he says the impeachment inquiry is unconstitutional, he's just wrong. He's just wrong.
Well, I agree with that. But the question is, he said, look, you're asking for witnesses who, I advised me as president. If I let them appear, then future presidents are not going to be able to speak candidly with their advisors. Also, some of these advisors have specialized security knowledge. All of that,
why didn't Trump go to court seeking a protective order to prevent the witnesses who defied?
Probably because his advisor said you're going to lose.
Okay.
But the bottom line is, in our system, a witness is entitled, tell me if you disagree with this as a trial attorney, a witness is entitled to refuse to show up. Now, the witness runs the risk. The witness could move for protective order, but if a witness refuses a subpoena, as these witnesses have, the witness runs the risk that it'll be enforced against him.
That's right.
Her.
Exactly right.
But the witness is not necessarily wrong simply because the witness didn't show up.
Well, if the subpoena is a lawful subpoena, they certainly are wrong. I have heard stories of jurors, forget about witnesses at a trial, jurors who ignore a subpoena to show up for jury duty. I've seen judges who've sent the marshals out after them.
Oh, no, I agree. And that's and because they didn't assert a lawful cause to ignore the summons. But what I'm saying is if the juror happened to have been if the prospective juror happened to be in a coma, and was incapable, and then they send the marshals out, and they come back and say, "Well, he was in a coma." I think the court would say, "All right, that's one of those."
But if the witness says, "I think this inquiry is a sham," and regardless of what actually is correct in terms of whether it's constitutional or not, I believe it's not constitutional and is a product of the do-nothing Democrats and their overlords in the mainstream media, and therefore I'm not going to show up. I mean, that witness is going to face consequences.
I know, but I completely understand. And actually, the McGahn case, because McGahn wanted to be protected, is going up, and that may give the precedent. But look, we're dealing with a Senate that we know certainly does not want to convict. And if Schiff had sought expedited enforcement of subpoenas, and I think he probably could have gotten them reviewed in record time, and I think he probably would have won. Now, there may be a couple of witnesses who the courts might say, well, there are certain lines of questioning that the witness can refuse to answer, or there may be certain. But I think Schiff would have won. And then if Trump refused, saying, I don't care, it's still a sham, I think it would have been very difficult for McConnell. But we don't have the neutral party, the courts.
That's right.
Input, and therefore you can get at least the veneer of some sort of neutral ruling from the Senate saying, well, I think Trump's excessive and I don't think he articulated it well, but his sense was correct. The impeachment inquiry was excessive. The subpoenas were excessive. And we therefore do not believe that this president represents an existential threat to liberty.
Well, we will see, because in a week's time, when this conversation goes out to the world, we'll see, as of today, Nancy Pelosi wasn't committing to even when or if these articles will be sent over to the Senate, for a variety of reasons. So anyway, we shall see. There might,
but you're looking for process. And we're talking about substance.
No, but I'm saying there may be the courts may have to weigh in at some point soon, before we know it. We'll have to see.
I hope. Anyway,
Peter, this has been so much fun, and so much to think about, and so great to talk with you and debate with you and ramble across the history of so many topics, but really coming back to the central premise of your argument, which I think is a powerful, and I hope people will enjoy listening and following along to. And again, we'll put in the description a link to your article. Again, I just think everyone should read Justice Kennedy's beautiful writing in the Obergefell decision, and we'll link to that as well. And thank you, Peter Baer, professor of law at UNLV Law School, and such a pleasure to have you on Good Law, Bad Law. Thank you very much.
Pleasure for me. Thank you.